Hello everyone. Welcome to VListen. I am Raviteja, an advocate with key interest on corporate and allied laws. In this podcast, we will discuss the recent Supreme Court judgment, Sandeep Khaitan versus JSVM Plywood Industries, wherein the Honorable Supreme Court postulated the contours of inherent powers vested in the High Courts in relation to the IBC. The brief facts of the case are that the appellant, Mr. Sandeep Khaitan, is the resolution professional of the corporate debtor, that is National Plywood Industries Limited. The respondent herein, that is JSVM Plywood Industries, is one of the operational creditor and a related party to the corporate debtor, as it is an associate company of the corporate debtor. It supplies raw material to the corporate debtor. After the initiation of CIRP, the respondent, being an operational creditor, filed its claim for over 6 crore rupees, and the same was vetted, verified and admitted by the appellant. While this is the case, the erstwhile board in the meantime had challenged and appealed the NCLT admission order before the NCLAT, and the same was dismissed. Further, agreed by such dismissal, they appealed the same before the Supreme Court. And the Supreme Court allowed the appeal and remanded the matter to NCLAT for considering the same as per the law. Subsequently, the former managing director filed an injunction restraining the RP from interfering with the management of the corporate data before the NCLT, and the same was disposed by directing the RP and COC to maintain status quo with respect to the insolvency resolution process. Further, NCLT ordered that RP is at liberty to act as per law. While matters stood thus, it was brought to the notice of RP that the former managing director, in conspiracy with the respondent, engaged in an illegal transaction by transferring 32.5 lakhs without the authorization of RP or COC to the bank account of the respondent under the guise of dues arising out of supply of raw material. RP, being apprehended of the fact, immediately filed a cyber complaint against the respondent, as the transaction was made through internet banking, and lodged an FIR against the respondent for criminal breach of trust and cheating with dishonest intention. In consequence to FIR, the bank created lien upon the respondent's bank account based on the alleged illegal transaction and froze its operation. Aggrieved by this, respondent filed an application under Section 482 Code of Criminal Procedure before the High Court of Guwahati for quashing of FIR, and inter alia sought an interim relief to lift the lien and defreeze the bank account of the respondent. The same was conditionally allowed by the High Court. The interim order of High Court had been challenged by the RP before the Supreme Court. The issue before the Supreme Court is that whether inherent powers of High Court under Section 482 Code of Criminal Procedure can countenance the breach of a statutory provision. Before we discuss what was held by the Supreme Court, please note that parallel to filing of cyber complaint and lodging FIR, the RP brought the alleged illegal transaction to the notice of NCLT Guwahati, which observed in its order that even if it amounts to discharge of debt due to the creditor, that is the supplier, the withdrawal of any amount during the CIRP without permission and knowledge of IRP or RP, as the case may be, is in violation of Section 14 of the Code dealing with prohibitions on account of declaration of moratorium. Now coming back to our issue as to whether inherent powers of High Court under Section 482 Code of Criminal Procedure can countenance the breach of a statutory provision. The Supreme Court is of the opinion that Section 14 of IBC is vehemently clear, subject to the provisions of subsection 2 and 3. The provision 2A was inserted later in time. No doubt under provision 2A, goods or services not covered under essential services under section 14.2 are also covered. However, the call as to whether the provision of any other goods or services is critical for managing the operation of corporate debtor as a going concern is to be taken by IRP or RP, as the case may be. In this case, the raw material supply could fall within the provision 2A. The RP must take a decision guided purely by the object of the IBC and the provisions and the factual matrix. The Supreme Court observed that the impact of moratorium includes prohibition of transferring, encumbering, alienating, or disposing of by the corporate debtor of any of its assets, and it further clarified that the assets of company would include the amounts lying to the credit in the bank account. Further, the power under Section 482 of Code of Criminal Procedure may not be available to the court to countenance the breach of a statutory provision. The words "to secure the ends of justice" in Section 482 Cr.P.C. cannot mean to overlook the undermining of a statutory dictate, which in this particular case are the provisions of Section 14 and 17 of the IBC, thereby implying that the mandate under Section 14 has indeed been violated by the respondent. It was also opined by the Supreme Court that once orders passed by NCLT admitting the application under Section 7 and also ordering the moratorium under Section 14 of IBC, and the orders which have been passed by the tribunal otherwise, the impugned order of the High Court resulting in the respondent being allowed to operate the account without remitting 32.5 lakhs in the account of corporate debtor cannot be sustained. And in consequence, Supreme Court modified the High Court order by directing the respondent to operate its bank account subject to it to first remitting into the account of corporate debtor the amount of 32.5 lakhs which stood paid to it by the management of the corporate debtor. The assets of the corporate debtor shall be managed strictly in terms of the provisions of IBC, and the RP will bear in mind the provisions of Section 14, subsection 2A and the object of the IBC. Holding thus, the Supreme Court disposed the appeal with a clarification that this order shall not be taken as pronouncement on the issues arising from the FIR, including the petition pending under Section 482 of CRPC before the High Court of Guwahati. With this, we finish our podcast. Thank you all. See you again in another interesting gambit of IBC.